Yep. Okay. Go!
Will you hand me my screen box?
Now go.
This is 242945, the People versus Carlos Harris. Appearances.
Good afternoon, Your Honor. Nancy Gasner requesting permission under MCR 8.120 to conduct this hearing.
Good morning, Your Honor. Alexandria Taylor appearing on behalf of the defendant, Carlos Harris, P 75271. Mr. Harris, please state your name for the record.
Carlos with a K, last name Harris.
Okay, and permission granted. Okay, so before we get into the, you can be seated, everyone. So before we get into whether or not we need testimony on this, I just have a few questions. I've reviewed all of the case law on this. I've read Pomeroy, I've read Wood, I've read, what's the third case on this now?
So we have Stephen, is that the one you're talking about? There's Pomeroy, Wood, Stephen, Chanella.
Fulcher. Which one? Pomeroy. It was the Pomeroy Fulcher court. And then this case, the Wood case, discusses Pomeroy in detail.
Right.
I need a few facts that I need to know if the parties are willing to advise. At the time that the stop occurred, and stops in quotation marks because the vehicle was alleged to have been stopped, was the vehicle in park?
Yes. The vehicle was parked but running.
Okay, but it was parked.
Yes.
It was in park.
Yes.
Okay. And the defendant was behind the wheel sleeping.
I don't believe the defendant was sleeping, but he was behind the wheel, yes.
He wasn't asleep.
Okay. I just saw that in the
That's
motion.
reflected in the
So for the prosecutor, when I read this Wood decision, okay, so they're basically parsing these cases into two types of cases. And they make this distinction between these cases that they've previously heard based on the evidence that came forward in Wood. So in Wood, we had an individual that was in his van at a drive-through window, and law enforcement stopped him and wrote him up for drunk driving. His foot was on the brake, but the vehicle was in drive. Okay, and they discussed that case, and then they come to a decision when they're reviewing Pomeroy, the Wood case, that there's this distinction specifically in the Wood case because the vehicle was in a position to cause significant risk of causing a collision. Such a person continues to operate it until it's returned to a safe position. So they basically say in the Wood decision, the fact that the defendant's the car was in drive and the foot was on the brake, if his foot slipped off, the car would be moving again. But in this case, we have a car that's parked, and I'm not certain how under Pomeroy and Wood, what the legal basis would be for the charge. Do you understand what I'm asking?
Yes, Your Honor. Your Honor, the people are relying on People versus Chanella, which allows for circumstantial evidence.
What's the citation?
It's People v.
It's 160 Mishap 213.
Yes. Thank you.
Okay, go ahead, I'm listening.
Yes, so it allows for circumstantial evidence to come in to show that the defendant was operating a vehicle under the influence prior to arrest. And that's what we're relying on, as well as the definition of operation, which is under MCL 257.6251, which doesn't require the officers to witness the vehicle in motion. And that's what this case is, circumstantial evidence to show that the defendant was operating the vehicle while under the influence prior to the arrest.
Can I respond, Your Honor? Are you ready?
Yeah.
You said yes.
So the circumstantial evidence has to be actual evidence. So just like in People v. Stephen, which is 262 Mishap 213, a 2004 case, in that case,
the court found sufficient evidence to support an OWI charge. And so there, the defendant admitted to driving to the fairground to sleep off the effects of having too much to drink. He struck the parking log while attempting to leave the fairgrounds and turned off the engine and went to sleep after he was unable to dislodge his truck. So yes, it can be circumstantial, but that's the circumstantial. There has to be something. The cite for that one?
No, read what you just said to me.
So the court found sufficient evidence to support an OWI charge where defendant admitted he drove to the fairground to sleep off the effects of having too much to drink, struck the parking log while attempting to leave the fairgrounds, and turned off the engine and went to sleep after he was unable to dislodge his truck. And that's at 219 and 220 within sight. So the circumstantial evidence, obviously, in Stephen was defendant admitted he had too much to drink and he physically hit something with his vehicle. And even though his engine was turned off, he was unable to dislodge his truck. He was stuck after hitting something. And so we don't have those type of facts here. And so yes, it can be circumstantial, but again, we don't have anything like Stephen and Shanella here. And we have the body cam. There's nothing here. There will nothing. If these officers testify pursuant to what is on the body cam footage, there won't be anything. And in fact, on the body cam at roughly, I think it's around 22, I think it was Officer Shields specifically remarked, and he said, well, his speech isn't slurred, like there was nothing. And so we don't have the circumstantial evidence that is found in these other cases, or even like the case Your Honor cited, People v. Wood. In that case, the defendant also had a beer between his legs. So it wasn't just that his foot was on the brake, he had a beer in between his legs.
What is
also in the
this?
drive-thru.
I'm sorry, I don't want to cut you off, but what 262 MA, what was the rest of that? Ms. Schaaf, what?
213.
Your Honor, may I respond to that as well?
You may.
I'd argue that we do have similar facts as to that. Unlike the case you just cited, the vehicle was running opposed to turned off, but also there were, after speaking to Officer Shields, he did mention to me that there were statements made before, as well as an interview conducted where he did state to drinking prior to and to also having driven and then stopped to take a nap or take a break. So I'd say that the facts are similar to that case.
Do you know if statements were made?
So the officer said, have you had anything to drink? And my client indicated that he had a drink several hours prior, and there were follow-up questions to that. And so, yes, and then he stated he had been at the hospital. I believe it was Mott's Hospital. His daughter was hospitalized. And so he said he had been at the hospital, and he was like, he was tired because he had been at the hospital. And so there was a statement, but different than in Stephen, the site that I just gave you, where that defendant admitted he had too much to drink. So saying I had a drink several hours prior, that is not the same as in that case that I cited.
Your Honor, may I?
Go ahead.
Thank you. We also want to add that there was a interview conducted where the defendant was Mirandized, where he again stated that he did drive this vehicle. He stated that he was taking a nap or taking a break or whatnot, and placed the vehicle at what they call, officer called it a gore, which is the middle of the, from a merger to the highway, which is, again, that's not a safe place to also put a vehicle. But he was the only individual in the vehicle, and the statements that were made before being Mirandized as well as being Mirandized were that he did drive the vehicle, and that's what we believe to be enough circumstantial evidence, at least at a probable cause standard, for this to be a question of fact or the trier of fact.
Hello, Officer Shields, can you hear me okay?
Yes.
Sir, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Can you state your name and employment for the record, please?
Mayan Shields, Michigan State Police.
Okay. Officer Shields, I know how your first name is spelled, but can you spell it for my court recorder?
Yes. CEMIAN
Okay, great. Madam Prosecutor, your witness.
Thank you, Your Honor. Good afternoon, Officer Shields. Could you please, well, you already stated your name on the record.
Amy.
Could you hear me or can you hear me?
Yes. Yes, ma'am.
Thank you. Okay, I want to take you back to the date of February 19th, 2023. Did your duties as a police officer take you at or near the location, East I-94 freeway near Telegraph Road?
Yes.
Is that in the city of Taylor, County of Wayne?
Yes.
And what were you in that area for?
And just on general patrol.
Okay, were you with anyone or were you by yourself?
I was with the partner,
Who was your partner?
Trooper Elia.
Okay, and were you in a vehicle at this time or on foot patrol?
We were in a vehicle, fully marked patrol, Michigan State Police vehicle.
And were you in uniform that day?
Yes, we were.
Was it full or partially marked, or was it full or modified uniform?
Full uniform of the day.
Okay, and were you, when you were in that area, what, if anything, did you observe?
I observed a black Cadillac SUV parked in the gore on the freeway.
And what is a gore?
The gore is the section between the entrance or exit ramps of the freeway that comes to a tapered V.
Okay, and do you remember if that vehicle was running or not at that time?
Yes, the vehicle was running.
Okay, and what did you do when you saw this?
I pulled behind the vehicle to check on the vehicle. We ran the license plate. I exited the vehicle, approached the vehicle, and observed a black male behind the driver's seat. He rolled down the window, and we began to interact.
And how many individuals did you see in that vehicle?
Just one.
Okay, and Your Honor, would you like identification or no?
I don't know how he's going to do that through Zoom for identification.
Okay, it's not an exam. Okay, so you made contact with the driver of that vehicle?
Yes, ma'am.
Okay, and did you observe anything when you made contact?
No, just that he was appeared to be waking up.
Okay, and what happened when you made contact with him?
I began to ask him several questions of where he was coming from, what was he doing, which led me to ask him if he had been drinking that evening.
And did he respond to any of the questions you were asking him?
Yes, he did. He told me he was he pulled over because he was tired. He was coming from I believe Ypsilanti.
Okay, and you stated that you also asked him, you were led to ask him a question about whether he had drank that night or that day?
Yes, I asked him if he had anything to drink, and he told me he had something around 8 p.m.
Okay, and why did you ask him that?
Just common questions for when we stop individuals. You may suspect something with their driving behavior that would lead you to believe that they may be impaired. The position of his car on the gore led me to believe that he may have been intoxicated, because normally when people pull over, they usually park on the shoulder, not in the gore, unless their vehicle was disabled or anything like that.
Okay, and what happened after he did tell you that he had a few drinks?
I would object to it. That wasn't the
He
testimony.
said he had a drink,
Yeah.
right?
A drink, I apologize. What happened after he made that statement to you?
Which statement?
The statements regarding the drinking.
Oh, I asked him to step out of the vehicle, and he complied.
Okay, and why were you asking him to step out of the vehicle?
Because I want to further investigate to make sure he wasn't impaired.
Okay, and at any time, did you make any other observations as to whether he might be impaired?
Yes. When he exited the vehicle, as I was escorting him back to my patrol car, I could smell the odor of intoxicant.
Okay, and then what happened after?
I ran him through a field sobriety test.
Okay, which field sobriety test did you recall?
Horizontal gaze and nystagmus was the first one. The walk and turn was not conducted due to the position of us on the freeway. It wasn't safe to do so, and the one leg stand.
Okay, and what happened during, let's start with the first test, the horizontal nystagmus, I believe you stated?
Horizontal gaze nystagmus.
Yeah.
Mr. Harris' pupils displayed equal tracking. There was no sign of resting nystagmus. There were no indicators of lack of smooth pursuit or any clues of impairment with the horizontal gaze nystagmus.
Okay, and then you conducted a second test. Was this the one-leg stand test?
One leg stand test. That test was administered. There were no clues also with the one leg stand test.
And what did you do after these tests were conducted?
Well, we had already called for PBT because he had requested that he would just take a breath test. We had already requested one, and one was en route. So as soon as that arrived on scene, we administered that, and that's when it was indicated that his BAC was a 0.12.
Okay, and after seeing the results of that test, what happened after?
Placed Mr. Harris under arrest.
And what was he placed under arrest for?
OWI.
Okay, and then was he later transported?
Yes. He was advised of I have to look at my report to make sure I get the order corrected, if you don't mind.
If it would refresh your recollection, do you have your report with you?
Yes, I do.
Okay, if you'd like to take a look at your report, you could.
Oh.
And then whenever you're ready, please just let me know. I can ask again.
Okay. Okay, after he was placed under arrest and secured in the vehicle, he was read his chemical test rights, in which he agreed to a chemical breath test. He was also read his Miranda rights, in which he stated he understood his rights and agreed to answer my questions.
Did you read the defendant his Miranda rights?
Yes.
Okay, and did he understand those rights?
Yes, he said he understood his rights and agreed to answer my questions.
Okay, and how did you read? Did you read them out loud or was it on paper?
Verbatim from a department issue card that we have. It's a UD52 card.
Okay, and where did this take place?
This took place in a patrol vehicle.
Okay, and at that time, did he appear to be under the influence of anything too?
No, his speech and everything was not slurred, other than odors of intoxicants and him admitting to consume some alcohol. There was nothing else.
Okay, and did you want to ask questions? You said so. Random. Did the defendant provide a statement?
Yes, he did.
And what did he say?
Would you like for me to read it verbatim?
Do you have, if you could, sure, yes.
Okay. When I interviewed Mr. Harris, the first question I asked him was, when was the last time you had something to drink? Answer was, I probably had something to drink around maybe 12:30 a.m., 12 o'clock a.m. I went to the charity room around 8 o'clock. Next question, where's that located? Answer, Ypsilanti on E-Course. American Legion. It's a lodge for veterans. Question, how many alcoholic beverages did you have while you were there? Answer, I probably had 2, and one of them I didn't finish. Question, what kind of alcoholic beverages were they? Answer, vodka, a double shot of apple Ciroc. Question, so 2 double shots of apple Ciroc, and that was the only thing you had? Answer, yeah. Question, what freeway do you think you're on? Answer, 94. Question, 94 where? Answer, 94 just. What do you mean 94 where? Question, where at on 94? Answer, I would assume it was probably Allen Park 94. Question, how about a cross street and which direction? Answer: I don't know all that. I don't live in Allen Park. Question: were you going east, west? Answer: I was headed east because I live down. Like I said, I live in Grosse Pointe Shores. I was headed home, but as I stated before, I thought I possibly should went to EMU, to Michigan Mox, but I was like, fuck it. I just head home. Pardon me. I just head home, but I've been calling my wife, calling everybody. Nobody answered. So I said, fuck it. Man, I just pulled over and took me a nap. Question: on a scale of 1 to 10 on the effect of alcohol has on you, where would you rate yourself? Answer: 2. And that concluded the interview.
Okay, and was that the end of your involvement in this case?
Next, he was transported to the Michigan State Police Detroit Detachment, where the data master was administered for the chemical breath test.
Okay, and I have nothing further. Thank you, Officer Shields.
Cross.
Officer Shields, is it fair to say that you don't know how long Mr. Harris was there?
That is correct.
And when you first encountered Mr. Harris, the vehicle was completely stationary, correct?
Yes, ma'am.
And so it will be fair to say you never personally observed that vehicle moving, correct?
That is correct.
Would it also be fair to say you did not observe any tire tracks, skid marks, or any other signs indicating recent movement, correct?
That is also correct, ma'am.
And you said that you instructed Mr. Harris to exit the vehicle and he complied with your instruction, right?
Yes, ma'am.
He didn't stumble out of the vehicle. He got out of the vehicle as normal, correct?
Yes, ma'am.
And it's also your testimony that out of the field sobriety test that you did perform, there was no indication of impairment, correct?
That is correct.
Now, I want to clarify something because you said that you had called for a PBT because it was requested. Is it your testimony that Mr. Harris requested it?
We had already requested a PBT, but he was asking his. I believe he said, "I'll blow in the machine," or just breath test me, or something like that. Of that effect. I can't recall exactly what he had said. I would have to review the body camera footage.
Okay, and so I'm just going to ask you if this would refresh your recollection from the body cam when you were doing the one leg stand and demonstrating that Mr. Harris had indicated that he had gout, correct?
Oh, yes, yes, ma'am. Yeah.
And at one point in time, there was a discourse about whether he was agreeing to do the test, and there was a mention of a PBT. However, Mr. Harris did the test successfully, correct?
Yes.
How long did you have to wait for a PBT to arrive?
I would say approximately 7 to 8 minutes. I would have to review the body camera footage to see from the time that we requested it till it arrived.
And also, it's fair to say there were no calls into law enforcement about a vehicle in the road, correct?
No, ma'am.
No reports of any accident or crash involving Mr. Harris?
No, ma'am.
His vehicle did not have any signs of indicating that it was an accident, right?
No, ma'am.
And in fact, isn't it fair to say that at one point on the body cam, you made a comment saying, well, he's not slurring his words, almost saying that there were no indications that you saw of intoxication, right?
That is correct.
And so outside of Mr. Harris being completely honest, saying, okay, I had a drink and didn't finish the second one, there was really nothing else, correct?
Correct.
All right, nothing further.
Any redirect?
No redirect.
Can this witness be excused?
Yes.
All right, thank you, Officer Shields. You're all set.
Okay. Thank you, Your Honor. Have a good day.
Yeah, you too. Is there another witness?
No, Your Honor.
Okay.
Your Honor, we would move to admit the body cam just for the record purposes.
Okay. Any objection?
No objection, Your Honor.
Are you going to provide me a copy of that?
Yes.
Okay. We don't have to watch that now.
No.
I can review it and then come to my decision.
Are we making final arguments or no?
I'd love to hear final arguments.
Okay.
Wait, you're first.
Yeah,
It's your
first.
motion.
Yes. It's easier for me to be right here. On my papers. Your Honor, the prosecution has failed to establish probable cause that Mr. Harris operated a motor vehicle while intoxicated as required under the statute. As a matter of law and under the facts of this case, bind over is improper. As we just discussed earlier, the premier case on this issue, People v. Pomeroy, 419 Mich 441, a 1984 case, where the Supreme Court held that a defendant could not be convicted of a drunk driving offense where he was sleeping in a motionless vehicle. As Your Honor articulated.
Ms. Taylor,
Yeah.
I don't want to interrupt, but this is a misdemeanor.
Yes.
Okay, because you said bind over.
Oh, I'm sorry. Yes.
Okay.
And so, as Your Honor has stated, since People v. Pomeroy, the court has refined that holding, and in People v. Wood, the defendant was found asleep behind the wheel with a beer between his legs at a fast food drive-through. The court found that there was sufficient evidence to believe that the driver operated the vehicle while intoxicated at some point. The case I cited previously, People v. Stephen, again, the court found there was sufficient evidence where the defendant admitted that he drove to the fairground to sleep off the effects of having too much to drink, struck something, and then his vehicle was dislodged. The same on People v. Shinella, that is the case where the defendant was in a ditch. Here, Your Honor, in this case, Mr. Harris was found inside a stationary parked vehicle. Officer Shields testified he did not know how long Mr. Harris was there, never saw the vehicle in motion, didn't see any skid marks, tire tracks, anything to indicate that the vehicle slid or was in an accident. There was no proof of movement, no time frame as to how long the vehicle had been parked, and no statements from Mr. Harris regarding recent driving. And even in the statement that Officer Shields read, the question and answers, Mr. Harris said, I went to take a nap. And so even if we look at the timeline of things when this happened, there is no evidence, especially considering Officer Shields' testimony here today of not knowing how long Mr. Harris was there. There's no evidence. And so, yes, Madam Prosecutor is right. It can be circumstantial, but here we have no circumstantial evidence. And even with Officer Shields, he testified that there, for the horizontal gaze nystagmus, there was no sign, no indication, the one leg stand, no clues of impairment. Mr. Harris got out of the vehicle without issue. And as I stated if Your Honor was to listen to the body cam, Officer Shields remembering his words almost like there's nothing here. And I contend that the testimony surrounding the PBT, Mr. Harris did not request it. During the course of the one leg stand, when the officer said, do you have any injuries that would prevent you from doing this? Mr. Harris said, well, I have gout. And so there was a discourse back and forth where it said, okay, if you refuse it, you have to do the PBT. But ultimately, Mr. Harris did not refuse. He did the one leg stand, and even with gout, performed that test successfully, Judge. And so short of the officer saying, okay, we're getting this PBT, there was nothing, no probable cause, no signs of intoxication, impairment, nothing at that point. And so there was nothing on the record, especially here today after Officer Shields testifying, showing that there was a reasonable inference of intoxication. And so it is our contention that they failed to meet the probable cause standard for bind over. And even, I know Officer Shields says today it was 7-8 minutes, the video will reflect the actual time, but even under Rodriguez versus United States, the officer can only keep you there within a reasonable time And once it passes that, absent independent reasonable suspicion, you have to let someone go. So at that point, before the PBT even gets there, Your Honor, Officer Shields says there's no indication of impairment. And so Rodriguez says that a traffic stop becomes unlawful if it is prolonged beyond the time reasonably required to handle the initial justification for the stop. Well, Officer Shields testified that he asked Mr. Harris to get out of the vehicle because, again, when he went up to the vehicle, he did not say that he smelled any odor of intoxicants. It didn't say that until after Mr. Harris got out of the vehicle, and he wanted to do the field sobriety test. The whole purpose of the field sobriety is to ensure that this person is not impaired or intoxicated. And so you do the field sobriety test, and then Officer Shields says he performs it, even clarifies he wasn't slurring his words. And so at that point, then to keep Mr. Harris beyond that, you run afoul of Rodriguez where it says, look, the initial justification for the stop, which really the initial justification was more so impeding traffic, which is a civil infraction because he's in this gorge. And then you walk up to the car, Mr. Harris says what he says, and then they ask him to get out. We want to check and make sure. You check and make sure, and there's nothing there. The officers confirmed no signs of impairment. No probable cause existed at this point, yet the officers unlawfully prolonged the stop, culminating in Mr. Harris's arrest. Your Honor, there's nothing here that would give rise to probable cause that Mr. Harris was operating while intoxicated or impaired. And so, Your Honor, we're asking that the court grant our motion in this matter and dismiss.
Thank you.
Thank you.
Response?
Thank you, Your Honor. The people are requesting that the motion, that defense's motion to suppress be denied. We believe that there is sufficient evidence to keep this case going. In response to defense counsel stating that there was no testimony stating how long the vehicle was there for, the officer didn't know how long the vehicle was there for. We believe that that's not something we need to really know. It's just we have to show that there was operation of the vehicle, not how long that it was there for. And we believe that that's been showed here. There were statements that were made before and after being Mirandized, indicating that the defendant was operating the vehicle, and there were also the vehicle being in the middle of an area that is, again, dangerous to have stopped there. There were, as Officer Shields testified earlier, that there was an odor of intoxicants when the individual was being asked to exit the vehicle, and this individual was being asked to exit the vehicle because the officer felt best to further investigate, based on the statements that were made, that the defendant was driving this, or that was drinking prior to. He felt that it was best that he further investigate just to confirm that he would be able to let this driver go and continue driving. This is a highway. It's not, you can't let a driver go without further investigating. If they could possibly be intoxicated or under the influence of something, that would just be a danger to everyone. And furthermore, yes, there were standardized field sobriety tests that were conducted and that were passed. However, everyone does hold their, I'd say everyone does handle their liquor better than others, or alcohol better than others. So whether he passed it or not, it could just be someone holding their alcohol better than someone else not. And as to the PBT or the further investigation, I believe the officer stated that the individual, there was some back and forth about PBT being requested, and that's why, again, the investigation was continued. We do believe that we did show enough to keep this case going, and if not, again, it's a misdemeanor. So if we believe that there could be a question posed for a trier of fact or for you, Your Honor, at trial. And based on everything that was heard today, we are asking that you deny defense's motion.
Thank you.
Your Honor, one thing I want to say, Madam Prosecutor says they don't have to show how long the vehicle was there. But again, this is a legal question. It's not just that they have to show that he was operating. They have to show that he was operating while intoxicated. And so that's the thing. That has not been shown. The circumstantial evidence in all the cases that have been put forth on this record, even the one cited by Madam Prosecutor, the circumstantial evidence that was in those cases, Your Honor, was far greater. Here we have nothing except Officer Shields admitting there were no signs of impairment. And so we have to go with what's on this record. That is a legal question and not a question of fact for a trier of fact. So we're asking that Your Honor grant our motion.
Okay, so I've heard, I don't need to watch the video unless someone wants me to watch the video. So I've heard testimony from Trooper Shields. I've also heard legal argument and reviewed several cases from the Michigan Supreme Court on down regarding operating while intoxicated. We have here a case where an individual was parked on a gore on the freeway. The vehicle was running, but the car was in park, and it appeared that the defendant in this case, Mr. Harris, was sleeping. And an officer performed, Officer Shields and his partner, Trooper Elia, performed what arguably was a Terry stop, right? They stopped the vehicle or pulled behind the vehicle because they have reasonable suspicion. And the trooper testified that the location where the vehicle was parked is what gave him the suspicion. So he approaches, this is a rendition of basically what I've just heard. He approaches the vehicle. He makes contact with Mr. Harris. He indicated he smelled intoxicants, but he requested that Mr. Harris perform field sobriety test, and Mr. Harris passed all of the sobriety tests. He testified there were no indicators of impairment based on all of these field sobriety tests. He testified he then called for a PBT, and it might have been 7 to 8 minutes that Mr. Harris was detained prior to that PBT taking place. And at that point, it's this court's view that the reasonable suspicion for the stop had concluded. He had taken field sobriety test. He passed the field sobriety test. There's been statements on record. I'm not reviewing the camera, but you're both officers of the court, that he indicated at one time to his partner, like, we don't, have anything. He's passed the test, yet they continue to detain Mr. Harris so that they can perform a PBT. The officer testified multiple times in multiple different ways that he wasn't slurring his words. There were no indications that he was intoxicated whatsoever. The vehicle was in park. It wasn't in a situation where it would cause immediate injury or immediate risk of collision as outlined in Pomeroy and later in Wood. After that, and the testimony is that essentially one statement was made that he had had a drink earlier. And that was the statement that was made prior to the PBT, prior to the arrest. And that was one statement that he'd had a drink at 8 o'clock. This is near midnight when the stop occurs. And after that, after the PBT, he's arrested, detained, Mirandized, and a statement is taken at that time. But if the Terry stop went too far and the Terry stop kept an individual at a scene after the reasonable suspicion had been cleared in order to effectuate further testing, anything that occurred after that would theoretically be or legally be fruit of the poisonous tree, right? So then what good does this Mirandized statement do for the prosecutor when the statement was made after Mr. Harris had been unreasonably detained under Terry and its progeny? There was no reasonable suspicion at that point when the PBT occurred, and he should have been released from the scene based on that. And I mean, whether or not, the fact that he later has a positive chemical test or a data master test, I'm not looking at the end result. I'm looking at how did law enforcement get there? And that Terry stop went too long because the reasonable suspicion was dissipated according to the officer's own testimony. So anything that happened after that point, it's this court's opinion, would be fruit of the poisonous tree. And the motion to suppress is granted.
Thank you, Your Honor. Thank you, Your Honor.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute an interpreter.
I need an interpreter when I cannot express myself somewhere.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in first. We're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, no taste. Trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.